very good morning once again to all of you. It is with deep sense of respect and reflection that we welcome you all to this memorial oration organized by the MCPPA. We thank each of you for being present on this solemn occasion and extend a warm welcome to our distinguished guests, past teachers, members of the academic and non-academic staff, and past pupils. To begin today's proceedings with a symbol of light, wisdom, reverence, we will now light the traditional oil lamp. As the lamp is lit, may it symbolize our collective remembrance, reflection, and continued hope. We now invite everyone to stand as we sing the school song, followed by Higgins Gita, a heartfelt tribute to our heritage and shared values. We now move to the offering of the floral tributes, a symbolic gesture of love and remembrance. It is now our pleasure to invite the Principal and the President of the MCPPA, Mrs. Sajivani Bandara, to address the gathering.
Good morning. Our distinguished orator, Ms. Prashanthi Mahindaratne, Trustee, Ms. Indrani Veeratunga, former Principal, Mrs. Nelum Senadir and Ms. Subba Sumarsekara, honored guests, my colleagues, members of the Musaeus College Past Pupils Association, and fellow Musaeites. It is both a privilege and a pleasure as the President of the Musaeus College Past Pupils Association and the Principal of Musaeus College to welcome you to this year's Musaeus Higgins and Peter D. Abrew Oration. Every great institution inherits not only buildings and traditions, but also ideas, the value it chooses to uphold, and the conversations it passes from one generation to the next. The Musaeus Higgins Peter D. Abrew Oration forms part of that inheritance, conceived through the vision of our late principal, Musaeus Pilapitia, it has become one of the college's most cherished traditions, welcoming back distinguished Musaeists to enrich the intellectual life of the institution that first shaped them. In many ways, this gathering is also a reflection of Mrs. Higgins herself. She believed in nurturing women who would engage thoughtfully with the world, question with discernment, act with conviction, and serve with compassion and humanity. More than a century later, those ideals continue to guide us. It is therefore particularly fitting that we welcome today Ms. Prashanthi Mahindaratne, an outstanding Musaeist whose professional excellence and intellectual rigor have brought distinction to her alma mater. For me, however, this welcome also personal. Over the past years, Prashanthi has been far more than a distinguished past pupil. She has been a trusted friend of the college and someone whose counsel I have valued greatly. Whenever I have sought her perspective, she has responded with generosity and honesty and remarkable clarity of thought. One example arose during the development of the life program at Musaeus. We recognize that although the history syllabus concludes in 1977, the Sri Lanka our students inhabit today has been profoundly shaped by the decades that followed. When I share this concern with Prashanthi, she did more than offer advice. She gave her time. On 2 occasions, she engaged our students in thoughtful discussion on contemporary Sri Lanka, helping them to understand not only the events, but also their significance and relevance to the society that they will one day lead. Her contribution to Musaeus extends beyond those sessions as well. Throughout my brief tenure, 2.5, she has been a steady source of encouragement and thoughtful counsel, never hesitant to ask difficult questions from me when necessary, nor reluctant to acknowledge what was working well. Her observations have always come from a place of genuine care for this institution. And on more than one occasion, her insights have prompted reflections that later proved invaluable. For that, Prashanthi, thank you very much. That perhaps is one of the greatest gifts an alumna can offer her school. Not simply pride in achievements, but continuing to investment in his future. It is therefore especially fitting that Prashanthi returns to Musaeus today as a scholar, mentor, a lifelong advocate for the values this institution seeks to nurture. Her life reflects many of the qualities Musaeus Higgins hoped every Musaeist would embody: integrity, courage, humility, and compassion. Serving something larger than oneself. On behalf of Musaeus College Past Pupils Association, it is my pleasure to extend a heartfelt welcome to our distinguished orator, Ms. Prashanthi Mahindaratne, and to all our honored guests. Prashanthi, welcome home. We're delighted to have you. We are delighted to have you with us and look forward to listening, learning, and reflecting together. Thank you.
To commemorate and honor the legacy we celebrate today, I now invite Joint Secretary of the MCPPA, Mrs. Chaya Srinamuni, to deliver the citation.
Mischief, thou art afoot. Take thou what course thou wilt, was what William Shakespeare said, perhaps not knowing that the class of 1985 would adopt that as their motto. Of course, taking shelter in the fact that our esteemed orator today has said these things herself, having penned vividly entertaining and illuminating descriptions of the various doings of the 1985 Gang of Friends in the 125th anniversary publication of Musaeus College. From exploding rubber seeds to testing the strength of pulp by attempting to glue a teacher to her chair. Chief guest, you will have to read more, I believe, in the publication. Our chief guest and her bosom friends, some of whom are here today, have lived the life of storybooks, are the real, live, naughtiest girls in the school, so brilliantly brought to life by Enid Blyton. And those memories are precious, worth more than any treasure. Edgar Allan Poe, in the Complete Tales and Poems of Edgar Allan Poe, says, and I quote, "Men have called me mad, but the question is not yet settled, whether madness is or not the loftiest intelligence, whether much that is glorious, whether all that is profound, does not spring from disease of thought, from moods of mind exalted at the expense of general intellect." Might I, with apologies to Edgar Allan Poe, replace madness with the words mischievousness and precociousness? Is it not these children who express themselves creatively and mischievously, as some might see it, are the ones who, when they mature into adulthood, change the course of history, are unafraid to take a stand, go against convention if need be, and lead others into the light? Our orator, Ms. Prashanthi Mahindaratne, is proof of that truth, and is one such person who takes on challenges, who speaks her truth, and makes her mark. Ethnic cleansing in Croatia, and the case against the former president of Serbia, Slobodan Milosevic. Prior to her tenure in the UN, Ms. Mahindaratne worked as a criminal prosecutor in the Sri Lanka Attorney General's Department, where she prosecuted egregious crimes, including homicide, sexual violence, terrorism, narcotics, white-collar crimes, and the first ever high-profile war crimes trial against military personnel for the crimes committed against civilians, the case of rape and murder of Prashanthi Kumaraswamy and 3 others. Since her return to Sri Lanka, she practices law as a senior counsel. She has also served as honorary legal advisor to the Prime Minister on human rights and accountability from 2015 to 2018, during which period she was a member of the government's working group on transitional justice and reconciliation mechanisms. She was responsible for co-drafting laws relating to transitional justice passed by the Sri Lankan Parliament, including the Office on Missing Persons Act No. 14 of 2016. She was appointed by the World Bank as Senior Legal Consultant to the Right to Information Commission in March 2017, and by the UNDP as Senior Legal Consultant to the Office of Reparations in 2019. She also led an extensive research project for the Right to Information Commission, which culminated in a report linking the use of the Right to Information Act to the achievement of UN SGD 16 in Sri Lanka. Having graduated from Sri Lanka Law College with first-class honors, she holds 2 LLM degrees in Public International Law, International Humanitarian Law, and International Criminal Law from New York University School of Law and University of London, and a diploma in Forensic Medicine and Science from the University of Colombo. She is a British Chevening Scholar and a Hauser Global Scholar. Her publications include Dealing with the Past, Sri Lanka's Time to Try Prosecuting Conflict-Related Abusers, published by the South Asian Center for Legal Studies in 2019, and Reflections on 2 Years of RTI in Sri Lanka, published by the Right to Information Commission of Sri Lanka in 2019. She regularly carries out pro bono litigation for the protection and conservation of fauna and flora. Much more closer to home, she was our very own Joint Secretary of the MCPPA and a senior member of the Executive Committee, and was instrumental in drafting the constitution of the MCPPA. She is, as was already said, always forthright in her views, and yet open to ideas and discussion, a combination that is rare and appealing. She is a great friend, a mentor, and a guide, and conducts herself with humility, compassion, and good humor. It is my great privilege to invite Ms. Prashanthi Mahindaratne to deliver the 28th Musaeus Higgins Peter D. Abrew Memorial Oration on the topic, The Laws of War Through the Buddhist Lens.
Thank you, Chaya, for that, what shall I say, overly generous introduction. And the video, I got completely distracted from my lecture now. So it's epic. Thankfully, I have my notes here. But I wonder if you noticed that while you were, of course, referring to my credentials, my close friends in the first 2 or 3 rows listening to you actually looked a little skeptical. I have no doubt that when they get back home, they'll be Googling me to verify if what you said was accurate. And from the bemused expression of Mrs. Senadira and Ms. Kanti Fernando, I have no doubt they are probably reminiscing my not so distinguished school career here at Musaeus. So I'd like to start off by thanking the Musaeus College Past Pupils Association, the executive committee, and the president of the association, Ms. Bandara, for extending this extraordinary honor in inviting me to render the Musaeus Higgins Peter D. Abrew Memorial Lecture for 2026. As they say, no honor is more complete than the recognition of the very institution that shaped you. So thank you. But I must confess, at first I had some concerns as to how I could establish a nexus between what I could speak here, which would have to be on law and accountability, which is my area of competence, with the ethos of the life of Musaeus Higgins. Because as we know, her legacy is not just the bricks and mortar of the school. It's more rather the Buddhist moral framework that she advocated. At first, these 2 subjects, law and accountability and the Buddhist philosophy, seemed unconnected. That is before I started reading her writings, her publications, where I noticed, in preparation for this lecture actually, where I noticed that she had built in the concept of accountability into her messages. The strongest evidence of this is in the garland of birth stories that she wrote in 1914, which is also called Jataka Mala, which is a record of the Buddhist Jataka stories. And as we know, the underlying message of Jataka stories is obviously karmic consequence. And of course, as we all know, the Buddhist thesis is the law of karma. In fact, I'll quickly share with you one of the stories that she wrote of, is the story of Shantivadin. I hope I pronounced that correctly. That Jataka story goes on that the Buddha, in a pre-incarnation as an ascetic, had been tortured by a jealous king who thought that the throne could grant him immunity from that terrible atrocity. And then she goes on to write as to how the king was immediately punished, or at least met his just deserts, through a natural disaster where the ground opened up and swallowed him into a fiery abyss. So she writes this to exemplify actually patience and compassion of the Bodhisattva, because she writes that the Bodhisattva maintained his patience and compassion while being brutally mutilated. But the prosecutor in me saw another aspect to that story. That is that crime must surely be followed by retributive justice. If not at the hands of the law of the land, then at the hands of the law of karma. But what's most significant about that story is that in 1914, long before the development of the modern law as we know it today, long before the concept of the equality of people before the law was ever entered into our law books, Musaeus Higgins taught the students of Musaeus that no man had unfettered power, that even kings must face consequences for their actions. And that to me captures the very essence of accountability. So I believe speaking of law and accountability here this morning surely sits well with the Buddhist moral framework that Musaeus Higgins advocated over 100 years ago. But I'd like to also explain to you why I picked law of war of all the different types of laws that I have practiced and that we know of. Why law of war this morning? That is because I wanted to eliminate some misconceptions, false narratives that keep floating around in our society about laws of war and war crimes. I'm sure all of you have heard of the international conspiracies to take war heroes to war crimes tribunals. I'm sure all of us are familiar with that phrase and that kind of rhetoric. And so I felt that having studied the subject of laws of war and having prosecuted war crimes, I would like to, whenever possible, eliminate, dispel these myths and misconceptions. So this is one such opportunity that I took. So let me start off by asking the question, what are laws of war? How does it differ from the ordinary domestic law of a nation? I'll answer that question for you. The laws of war is a code of conduct that governs how a party to an armed conflict could conduct itself. The laws of war apply exclusively during armed conflict, both in respect of international armed conflicts as well as non-international internal armed conflicts. It does not govern conduct of people during peacetime. Now, an armed conflict could occur between two states or multiple states, and then it would be labeled as an international armed conflict. For example, you have right now the US-Iran conflict going on, and that's an international armed conflict because that's between sovereign states. Or it could be a non-international armed conflict, internal armed conflict, where within a state, the conflict is between armed forces of the government of the state and rebel groups, or amongst groups within a state, such as, for example, the 30-year war where here in Sri Lanka, where government forces fought against the LTT. That was a non-international internal armed conflict. So the laws of war govern as to how a party to a conflict, be it a state, be it a government, or a rebel group, would conduct its hostilities once a war or a conflict starts. Now, whereas domestic law of the land governs the conduct of the people of a state, territory of a state in their day-to-day affairs, which should principally be peacetime activity, that is non-conflict related activity. So to start off, the laws of war, the technical term for laws of war is international humanitarian law, and you might have heard by its abbreviation IHL, which is also referred to in the Latin term jus in bello, jus as in written with JUS. There is also another arm of international law that is applicable to wars, which is referred to as jus ad bellum. This is the law that dictates as to when a state or a country can go to war against another state. I thought of using some Latin terms just to impress my friends to show how learned I am. Now, this particular sphere is governed by the provisions of the Charter of the United Nations. In terms of Article 2, Subarticle 4 of the UN Charter, a state is prohibited from attacking or invading another state. It's a complete prohibition, subject to only one exception. And that exception is provided in Article 51 of the UN Charter, which allows a state or a collective group of states to attack another state in self-defense against an armed attack upon itself or against another member of the United Nations. So to reiterate, a state can go to war against another state only in self-defense and under no other circumstances. But as we know, regrettably, this fundamental rule of laws of war is regularly complied with in the breach. Take, for instance, the 2003 invasion of Iraq by the US and a coalition of allies. And the more recent 2026 unprecedented operation by the US against Venezuela to oust President Nicolas Maduro. And of course, the ongoing US-Iran conflict. Now, these wars, where, for example, the US and Israel carried out coordinated attacks against Iran. So these attacks, I say, and the international community will definitely say it and have been saying it, are ex facie illegal in international law because they are not carried out in self-defense. They are carried out for regime change or for other extraneous purposes, such as the interest in the oil resources of those countries or the resources of those countries that are invaded. But if you follow the pre-attack rhetoric, pre-attack false narratives that are offered by those attacking countries, you will note an attempt to purportedly invoke their right to self-defense in those instances to justify the attacks. It's a pretext. Now, in the case of the invasion against Iraq, the Bush administration, for instance, falsely claimed that Iraq possessed weapons of mass destruction, and which placed actually the survival of the United States at risk, and hence the attack was purportedly in self-defense. But since then, we all know that that was a completely false claim. And in fact, the reason was, again, regime change of Saddam Hussein's regime and the interest in the oil resources of Iraq. In the case of Venezuela, for example, the purported justification was, by the Trump administration, was that Venezuela was trafficking mass-scale drugs into the United States, which posed a threat to the US. Again, trying to, offer a pretext of self-defense. But yet again, as we know today, the interest was regime change, and rather their interest in the oil resources of Venezuela rather than stopping drug trafficking. And of course, the present ongoing conflict in Iran, the purported justification offered by the Trump administration again was that it was a preemptive strike against the imminent threat posed by Iran's nuclear capabilities, whereas the motive appears to be yet again regime change in the interest of Israel's regional objectives, agendas. So this is the geopolitical dynamics that the international law tries to regulate, I say quite unsuccessfully, as we can see from what's going on. But for our discourse this morning, I'm going to focus on the earlier arm of the law that I refer to, laws of war, or international humanitarian law, jus in bello. Now, for this arm of the law to be triggered, it matters not who started the war or who did what rightly or wrongly. Regardless of who did what, this law dictates what a party can do or cannot do once the war starts. Now, this sphere of the law regulates the conduct of hostilities between warring factions. If I may add a footnote here, because there are some very erudite international law scholars in the audience, so I have to be very precise here. I use the term war crimes in a colloquial sense, not based on legal definitions, because in terms of the international law, there are different categories of conflict-related crimes. For example, depending on the elements of the crime, they could be crimes against humanity, or war crimes, or violations of the laws of war, etc., which would be far too technical, legalistically, for this conversation. So therefore, I'm just merely using the term in a colloquial sense, lest when I go out, people might accuse me of saying the wrong thing. So war crimes doesn't mean a party's engagement or participation in battle against an enemy force. This is where we come to that misunderstanding or misconception of what a war crime is. For example, now Sri Lankan government security forces fought the LTTE. That's completely lawful. That's what you call legitimate battle. Now in an armed conflict, it is lawful for combatants, and whom I mean by combatants are soldiers, the fighting forces, to attack enemy combatants and the military installations of the enemy forces. Those are called military targets. The enemy combatants and military installations of enemy forces are called military targets. And it's absolutely legitimate to fire and attack military targets in war. So the term war crimes does not mean the participation of the fighting forces in combat or in a conflict. For example, when an officer of the Sri Lanka army or a soldier of the Sri Lanka army fires at an active combatant of the LTTE, please note I use the word active, and kills him or her, or destroys a LTTE hideout by bombing it and killing an entire unit of the LTTE, that's not a war crime. That's completely legitimate. Please note, I did mention the word active, and I'll get back to that later on. And vice versa. When the LTTE, notwithstanding the proscription as a terrorist organization, attacks an active platoon of the Sri Lanka army or bombs a military installation of the Sri Lanka army, that's also not a war crime. That will be a crime under the Prevention of Terrorism Act or the ordinary law of the land, but it's not a war crime under the international humanitarian law, because the active soldiers of the government security forces and government military installations are deemed military targets in conflict. And as I noted, it is completely lawful under the laws of war to attack military targets, whether they belong to government security forces or rebel groups. Now here I would like to pause a little to share with you a personal experience I had in prosecuting war crimes. Right here in Sri Lanka, so you can appreciate the distinction between the mere participation of a combatant in conflict, in a conflict combat activity, vis-a-vis war crimes, which are criminal acts. This is actually a very high-profile case. Many of you have heard of it, and Chaya referred to it. This is the case of rape and murder of Prashanthi Kumaraswamy and 3 others. You can read up on it on the net, there's much written on it. This was Sri Lanka's first ever prosecution of military personnel for conflict-related crimes. But I must caution you that some of the details that I would now describe in respect of that case might be disturbing to some of you. So for that, I apologize in advance. One fateful afternoon, almost 30 years ago, on the 7th of September 1996, 18-year-old Prashanthi Kumaraswamy, an A-level student of Chundukuli Girls High School in Jaffna, was cycling home after her chemistry exam, A-level chemistry exam. And going home, she had to cycle past the Kaithadi army checkpoint, which was manned by a platoon of soldiers of the Sri Lanka army. At the army checkpoint, the unit of soldiers, commanded by a corporal, stopped and detained Prashanthi, took her into the bunker, gang raped her, and murdered her by strangulation with a rope. Her naked body was then buried behind the checkpoint in an area now well known as the Chemmani mass grave sites. Her uniform and other attire were also thrown into the pit. Now, when Prashanthi failed to return home, her mother, Rasamma, who was a school principal, her 16-year-old brother, Pranavan, and a neighbor, Kirubamurthy, went in search of her on their bicycles. As you know, during the conflict, the mode of transport in the north was bicycles. Now, upon hearing, they had heard that Prashanthi had been seen being questioned at the Kaithadi checkpoint, military checkpoint. They too had gone to the checkpoint and had asked the military personnel posted there as to where Prashanthi was. The panic-stricken soldiers, fearing that their crime would, will be revealed, wanting to cover up, detained Prashanthi's mother, brother, and the neighbor also in the bunker, and murdered the three of them also through strangulation with ropes. Their bodies too were buried in the Chemmani grave sites. When the report of the missing 4 people reached Colombo, the then President, Mrs. Chandika Bandanaka Kumaratunga, requested the then Attorney General to send a state counsel to Jaffna to direct investigations. The case was assigned to me, and I flew into Jaffna in the midst of the war. This was 1996, with the CID and the military police in an Air Force military personnel carrier. Now, I was quite a young prosecutor then, people keep asking why I was sent. It could be because I was perhaps the only dispensable state counsel who could be sent into the theater of war. I don't know. I like to think that the AG thought well of me, but who knows. But regardless of the ongoing war, we conducted a very successful investigation within the theater of war itself. We succeeded in recovering the burial sites. We exhumed the 4 bodies 5 weeks after the crime, so they were in an advanced state of putrefaction. We identified the perpetrators with the assistance of the military police and secured adequate evidence to charge them. We indicted 7 soldiers, including the corporal, for abduction, rape, and murder of Prashanthi, and abduction and murder of her mother, brother, and neighbor before a trial at bar. That's a bench of 3 judges in Colombo here, and I prosecuted the case along with a team of prosecutors. And we concluded the case within 1 year and secured convictions against 6 of the accused. 1 was acquitted. All 6 convicted soldiers, including the corporal, were sentenced to death, which is the mandatory sentence punishment in our law books for the crime of murder. For those who might not be aware, since the 70s, no one has been executed in Sri Lanka, so those who are sentenced to death actually sit in what is known as the death row. Now, at sentencing, just before the sentence of death was passed against Corporal Somaratna Rajapaksa, that's the first accused in our case, he revealed in open court that the burial site in Chemmani comprised of mass graves containing over 300 to 400 bodies of people killed by the military. That led to the exhumations of the Chemmani mass graves. You probably have read about it. It's ongoing even right now. Over 400 bodies have been exhumed. Now, that's what you call a war crime, where innocent civilians are raped and murdered under the cover of war. I have no doubt that there is no one here who would disagree that that was a crime that warranted very severe punishment. It's not a legitimate conduct of war. It's not done to defeat the enemy forces. It was an egregious crime committed solely to satiate the individual carnal desires of the soldiers. Prashanthi, Rasama, Pranavan and Kirubamurthy were not collateral damage. They were the victims of premeditated atrocities that had no place in the conduct of war. They were what you call victims of war crimes. And the perpetrators cannot be called war heroes. War heroes are soldiers and officers who carry legitimate combat to defeat an enemy of the state. War heroes don't rape women and deliberately kill innocent civilians or those who have surrendered to them. The reason why I opted to start off with that very difficult case is that in Sri Lanka, most civic-minded people demand accountability for crime, be they corruption or sexual violence or narcotics or terrorism or the daily incidences of murder and child abuse, etc. But when it comes to conflict-related crimes, there's a deafening silence. Maybe could be partly because of this misconception of what war crimes are. So moving on to the subject matter, now I don't intend to dive into a highly technical presentation of the laws of war, taking you from rule to rule of the IHL conventions, because I can see my friends are really waiting to run out now, already. But the laws of war, because it's not a subject that can be conquered within 1 hour, because the laws of war includes complex legal concepts and very intricate jurisprudence delivered by international tribunals on very, nuance, including nuanced technicalities. It's not a subject that can be actually covered even within 4 years. But I will try to offer you a bird's eye view of the laws of war and examine how they resonate with the Buddhist principles and values that Musaeus Higgins has advocated. Now, the principal source of laws of war are the 4 Geneva Conventions of 1949, and there are 2 protocols that were adopted in 1977. Then there are also the Hague Conventions, which regulate the methods and means of warfare and military targets. The Geneva Conventions are a set of 4 multilateral international treaties entered into in 1949 post World War II. Now, to add a footnote here for the benefit of those who might not be familiar with the parlance, a multilateral convention or a multilateral treaty means an international agreement between 3 or more sovereign states or international bodies, organizations. These pacts are legally binding and establish unified rules, standards, and frameworks to govern complex global issues such as trade, environmental protection, human rights, and in the case of the Geneva Conventions, the conduct of war. The Geneva Conventions are a set of rules that seek to limit the effects of armed conflict on both combatants and civilians. They protect individuals who do not participate in combat, such as civilians and medics, and also combatants who no longer participate in combat, such as the sick, wounded, or shipwrecked soldiers or prisoners of war. Now, although the present-day Geneva Conventions were adopted in 1949, the origins of the Geneva Conventions go back to the 1800s. I thought I would give a bit of historical context too, less, I don't impress you enough to show that I have some historical understanding of the subject matter. Well, the Swiss businessman Henry Dunant, after witnessing the horrors of the Battle of Solferino in 1859, wrote a book titled A Memory of Solferino, which was published in 1862, wherein he made an impassioned plea to create voluntary relief organizations, societies to help wounded soldiers. So it started with wounded soldiers. This led to the creation of the International Committee or the Red Cross, ICRC, in 1863 and the first Geneva Convention in 1864, which was aimed at providing relief to wounded soldiers in the battlefield. Then in 1906, the convention was extended to provide relief to soldiers wounded at sea. And thereafter, a further convention was adopted in 1929 to specifically protect prisoners of war. So that was the genesis of the present day laws of war. Then the present day 4 Geneva Conventions were adopted in 1949 after World War II in response to the massive atrocities committed during the war. They replaced the previous 1800, 1906, 1929 Geneva Conventions that I just described. Now, the Geneva Conventions of 1949 are unique in that they are ratified by all countries in the world, so making them universally binding. Now, of the 4 Geneva Conventions, this first Geneva Convention places an obligation on a party to a conflict, be they government forces or governments or rebel groups, to protect wounded and sick members of the armed forces in the battlefield. It mandates humane treatment of sick and wounded soldiers even if they belong to enemy forces, and to provide medical care to them without discrimination. Now, the law strictly prohibits killing, torturing, or causing any harm in any manner against wounded and sick members of enemy forces, and provides for what you call medical neutrality. Medical neutrality is the principle that medical personnel must remain non-partisan and be allowed to treat the sick and wounded without interference, regardless of the patient's political or military affiliation. It is legally binding. It's a legally binding cornerstone, I say, of the international law aimed at preserving access to essential health care to all during conflicts. The rule is that the wounded and the sick soldiers, whether friend or foe, must be collected and cared for. That's a simple rule. A doctor or a hospital cannot refuse to treat, saying that the patient is an enemy of the state. Likewise, there is a strict prohibition in attacking medical units and hospitals, and consequently, all warring factions are required to identify hospitals, medical units, and ambulances, etc., with the Red Cross, visible from land, air, or sea, to obviate the possibility of any hostile actions to them. So, under the Geneva Conventions 1, the rule is simple. If an enemy soldier is out of the fight, you don't shoot or harm him. If the soldier is wounded or sick, you treat them. You don't kill them, you don't torture them. This is a perfect example I would like to share with you of the Geneva Conventions 1 in operation was during the Falklands War between Britain and Argentina in 1982. Some of you may not have been born then, but some of you will definitely remember it. Now, during that conflict, a British field hospital was set up behind the lines. Both sides knew where it was. When the shelling started, the British commander radioed the Argentinians saying, "We have wounded, do not fire." And the Argentinians immediately stopped for 4 hours. 4 hours of humanity in the middle of an international war. That's Geneva Conventions 1 working perfectly. But let's go step outside the legal parameters, going beyond the law. Does it not also resonate with the Buddhist ethos of metta, loving kindness, that Musaeus Higgins advocated. In terms of the first Geneva Conventions, when you see an enemy soldier who cannot fight back, the metta, loving kindness that is taught in Buddhism, becomes a law of the war. Now that was my aha moment. The more I thought about it, the more I could see the Buddhist virtues intricately woven into the laws of war. And that's what I found most intriguing. While war represents the antithesis of the Buddhist principle of non-violence, yet the modern laws of war that is required to regulate the conduct of war heavily rely on the Buddhist virtues. This is something really interesting. I don't take credit for finding that. I'm sure somebody else also has written on this. Although for the time being, I will take credit as perhaps the original source, but I'm sure you will find this if you Google. So if you think about it, compassion, restraint, and the protection of the innocent are central Buddhist teachings, closely mirroring what I just said, the core humanitarian values embedded in the laws of war. Let's also examine to see whether that is the case with the Second Geneva Conventions. Now, in Second Geneva Convention, I would like to really focus on one particular rule, Article 12 of the Geneva Conventions 2, places the legal obligation on the parties at war to protect the wounded, sick, and shipwrecked combatants at sea, and mandates that they shall be treated, it's absolutely mandatory, shall be treated humanely and cared for without any adverse distinction. So the rules further expressly prohibits attacks on hospital ships and medical personnel. These protections apply under the laws of war, provided the medical personnel and hospital ships are not used to commit harmful military acts outside their strictly humanitarian functions. Let's consider again, let's try to see how they resonate with the Buddhist values. Now consider the law that requires a warring party to collect and care for the wounded, sick, and shipwrecked combatants of the enemy forces without discrimination. Does it not resonate with karuna, compassion, a fundamental Buddhist value? Not compassion for one's own only, but for all sentient beings in distress. Now, at sea, where shipwreck makes everyone equally vulnerable, the Second Geneva Convention is a law giving form to that Buddhist virtue, Buddhist ethos of karuna. If you analyze Article 12 of the Second Geneva Convention, you will note that it captures the essence of the Dhammapada verse. Hatred is never appeased by hatred. By non-hatred alone is hatred appeased. Again, consider the Buddhist value upekkha or equanimity, which is the practice of maintaining an even, unbiased mind and treating all living beings with the same respect and fairness, free from prejudice, favoritism, or discrimination. So, on a sinking vessel in the theatre of war, for the monk, the sailor, the combatant, the civilian, suffering is the same. To choose who deserves aid, who deserves to be rescued, based on uniform or nationality or race or ethnicity, is to abandon equanimity. So the rule of non-discrimination in the laws of war is the provision, the legal provision that mirrors the Buddhist principle, upekkha, equanimity. So I would most respectfully submit to this gathering that the Second Geneva Conventions codifies into the law these Buddhist values. Now, I'd like to share with you one of the instances of the convention to working at its best, which is most surprisingly attributed to a naval commander, a German naval commander of the German forces during the Second World War, even before the Second Convention was adopted. This was the legendary Laconia incident of September 1942. Some of you may have read about it. A German U-boat attacked and sank the British troop ship RMS Laconia, and when the German U-boat commander surfaced, his submarine, after sinking the British vessel, he got intelligence reports that the British vessel carried 1,700 Italian prisoners of war alongside British civilians and troops. So the German commander, now his name was Werner Herrnstein, initiated a massive humanitarian rescue operation, providing blankets, pulling survivors from the water, and broadcasting their coordinates to the Allied powers so that they could assist in the rescue. This was truly an exceptional moment in the world's history, when a German commander, in the course of World War II, in the midst of unimaginable atrocities being committed by his own German forces elsewhere, demonstrated compassion for the enemy forces who were drowning at sea after battle. Exceptional, a perfect example of a German commander adhering to the laws of war. Of course, regrettably, clearly, Commander Bernstein's moral compass was not shared by the rest of the German forces, because after that incident, the German naval hierarchy issued the infamous Laconia order to the entire German U-boat force, forbidding the rescue of survivors of sunken ships. Let's move on then to the Geneva Conventions, the Third Geneva Conventions of 1949, which relates to the treatment of prisoners of war. Prisoners of war, as you know, are those who have surrendered, the soldiers, combatants of the enemy forces who have surrendered or who have been captured and taken prisoner. Now, the core idea of the Third Geneva Convention is that once an enemy combatant is no longer fighting and captured, they must be treated humanely. So, in terms of Article 13 of the Geneva Convention 3, I quote, "Prisoners of war must at all times be humanely treated, protected against acts of violence or intimidation, and against insults and public curiosity. And they have to be provided with adequate food, shelter, medical care, and respect for dignity." This mirrors several Buddhist virtues and values. Karuna, compassion, applied at the exact moment it's most difficult, when the other person was your enemy minutes ago. Metta in practice, loving kindness towards your enemy forces, now disarmed and now in your custody. So this is in fact, actually, if you consider the Buddhist virtue of metta codified into law. So to be steeped in these Buddhist values is to remember that dignity does not surrender when the soldier does. To see a person in your custody not as a trophy, but as a human being. The Geneva Conventions prohibits reprisals against prisoners of war. You do not punish today's captive for what your side suffered yesterday. A very Buddhistic approach, if you think about it. This is also upekha, equanimity in practice. not being pulled by anger or vengeance or tribalism. If you think about it, this is really Dhammapada formatted into a legal provision, where the Dhammapada says, for never do hatred cease by hatred, but by love does it cease. Now, a perfect example of the third Geneva Conventions working perfectly was in fact in respect of our own conflict. Because after the end of the hostilities in 2009, over 12,000 LTT cadre were taken into state custody. And the ICRC, alongside with the Sri Lankan authorities, worked to ensure that they were treated in conformity, in adherence to the Geneva Conventions, the third Geneva Conventions. They were registered, allowed family contact, medical care was provided, and finally rehabilitation and reintegration, release and reintegration processes rather than summary punishment was allowed. So there you see, choosing to see the captured combatant as someone to be reintegrated into society, not merely defeated and punished, mirrors the Bodhisattva ideal, to save even the one who harmed you, because life has more value than victory. I can also share with you an example when the provisions of the Geneva Conventions 3 was blatantly breached in the course of an international conflict by the US, in fact, in the 1991 Gulf War. There are reports that US troops or those aligned with the US government paraded Iraqi prisoners of war on television, and you may recall the world condemned it. Now, this was a blatant breach of the laws of war, because in terms of the third Geneva Conventions, prisoners of war must not be exposed to public curiosity. And now I'm sure you will appreciate why I used the term earlier that it is legitimate under the laws of war to attack an active enemy combatant. You will recall I used that term active. That is because if the enemy soldier has laid down his arms due to sickness or injury or being shipwrecked, or is a prisoner of war, then you cannot attack them. Then in terms of the Geneva Convention rules that I described, Geneva Conventions 1, 2 and 3, they cannot be harmed or killed. The law dictates that they shall be treated humanely. Of course, they can be tried for the crimes they committed during the conflict, under the law of the land. For instance, if Prabhakaran or the LTT leadership was taken in alive, the next step should have been to prosecute them for war crimes. And I believe, in fact, even today, there are some LTT leaders present, even in Sri Lanka. So obviously, they should be, in my view, tried under the law of the land. If you don't have international law adopted into the domestic law of the land, you prosecute, as we did in the case of Prashanthi Kumaraswamy, under the domestic law of the land. I'm glad that Chaya is present here, because from the Attorney General's Department, that's where it will be initiated, no doubt. Monday morning, there will be a memo going to the Honorable Attorney General. So let's now move on to the last of the Geneva Convention, the fourth Geneva Conventions, which in my view is the most important convention of the laws of war. The fourth Geneva Convention is referred to as the Geneva Convention relative to the protection of civilian persons in times of war. It sets down the rules for the protection of civilians at time of war. This is the first international treaty to exclusively focus on humanitarian protection for civilians during armed conflict. You may recall the Geneva Conventions 1, 2 and 3 that I just described provide for the protection of combatants or soldiers who have laid down their arms because of sickness, injury or shipwreck, or they are prisoners of war. Now Geneva Conventions 4 shifts the focus to civilians. The Fourth Geneva Convention codifies the ground norm in international humanitarian law, namely that civilians who take no part in hostilities must be protected from the effects of war. The key provision of Geneva Convention 4 is Article 27, which provides that civilians are entitled in all circumstances for protection in respect of their person, physical safety, their honor, their family rights, their religious convictions and practices, and their customs. The Convention directs warring factions to ensure that at all times civilians must be treated humanely, shielded from violence, threats, and public curiosity. Women are especially protected against sexual violence. So the Fourth Geneva Convention dictates that you cannot attack civilians, that you cannot attack civilian settlements, you can't kill or torture or cause injury or harm of whatsoever nature against civilians. Women are specially protected, and the convention expressly prohibits rape, enforces prostitution and sexual assaults against women. You cannot starve civilians, you cannot deport them or forcibly displace them, and you cannot use them as human shields. Collective punishment is prohibited. Hostage taking of civilians is prohibited. You cannot attack protected sites such as hospitals, schools, and cultural sites. Pillage, that is looting of civilian settlements, is prohibited. Reprisals against civilians and civilian settlements are prohibited. Coercion to obtain information is prohibited. And discriminatory treatment against civilians is expressly prohibited. So if you viewed these laws through the Buddhist lens, you will recognize the Buddhist principle of karuna behind this law, that is compassion extended to those who cannot defend themselves. The Buddhist concept of karuna requires you to protect the vulnerable, not harm or violate them. This is the exact thesis of the Fourth Geneva Conventions. You will also recognize therein the Buddhist value of upekka, equanimity. The duty of a warring party to protect civilians does not change because of their ethnicity, race, religion, nationality, or political opinion. And you can surely recognize that these rules of IHL, International Humanitarian Laws, are based on the central concept of the Buddhist philosophy, metta, loving kindness, codified into law. I find the notion of kindness behind the laws of war quite remarkable. It dictates to warring factions to protect a family's right to stay together in displacement and to even allow worship in occupation. This is because the laws of war see the civilian as a fully human, not as an obstacle to military aims. The provisions of the Fourth Geneva Conventions resonate with the Buddhist teachings to protect the vulnerable first. Now, to be guided by Buddhist values here is to remember that the measure of humanity in conflict is how we treat those with no uniform, no weapon, and no voice at the negotiating table, remembering that civilians never decide when to go to war or when not to go to war. It's another force that always take these decisions. They have no say in that. And a concrete example of the rules of the Fourth Geneva Conventions working in practice is the establishment of humanitarian corridors and civilian safe zones in conflicts, especially in internal conflicts, for example, in the Balkans in the 1990s, the conflict in the former Yugoslavia. Now, yet, I'm sure you're listening to this and you might be wondering, how does one spare civilians in a situation where there are bombs falling all over, like it happened in the final phase of the war in Sri Lanka, like it's happening in Iran right now? how do you distinguish between civilians, and how do you spare them? That's where the international humanitarian law principle called the principle of distinction comes into play, where the warring parties are at all times required to distinguish between civilians, civilian objects, and military targets, and only targeting the latter. So that's what you call the principle of distinction. Now, the duty to distinguish civilians from military targets, targeting only the latter, is the core rule of international humanitarian law. In fact, IHL rule is that in case of doubt, do not fire. That is, say, Article 50 and 57 of the Additional Protocol of 1977 provides that if there is doubt whether a person is a civilian, that person shall be presumed to be a civilian, and then you cannot attack. But then, of course, what happens when combatants and civilians are mixed up, mingling with each other in such a way that the attacking army cannot differentiate between civilians and combatants? Combatants you can target legitimately, civilians you can't, you are prohibited from targeting. But they are mixed up. What does a commander of an attacking force do then? Now, this is a serious dilemma. And this problem is further compounded if the combatants are attired in civilian clothes, they are disguised as civilians. Then you just cannot differentiate between the enemy combatants disguised in civilian attire and the real civilians. Now, how does the principle of distinction work here? What are you supposed to do? Are you supposed to just simply not attack? What do you do? This in fact, I must say, happens quite often in internal conflicts. This happened in the former Yugoslavia. This happened, in fact, in the Sri Lankan conflict too, where combatants dressed up as civilians and mingled with civilians in order to be immune from attack. Sometimes combatants even place themselves within hospitals and schools, knowing that those locations have immunity from enemy fire. Now, this is where the IHL principle called proportionality comes into play. The principle of proportionality means whether the collateral damage from an attack was proportionate to the military advantage anticipated from that attack. Actually, the law is very nuanced there. Whether the collateral damage anticipated from an attack was proportionate to the military advantage anticipated from that attack. It's very nuanced, and if you don't understand it, you can't be blamed, because it took me about 4 years to understand this. So, let me elaborate. Let me simplify that. So, the law is clear. You cannot deliberately target civilians. But if you fire at military targets and civilians are killed or harmed, or civilian objects are destroyed due to their proximity to the military targets, that's when you have collateral damage. To reiterate, the civilians or civilian objects were not the target, but they became collateral damage due to their proximity to the military targets. Then the question is raised, how much of collateral damage does the law of war allow? What is the proportionality of collateral damage that the law allows? There is very clear jurisprudence on this matter in the judgment of the International Criminal Tribunal for the former Yugoslavia, where I worked, in the case of Prosecutor versus Major General Stanislav Galic. I was a prosecutor in that case, and the case is better known as the Siege of Sarajevo. Just to give you a bit of background information, Sarajevo is the capital of Bosnia-Herzegovina, which is a republic of the former Yugoslavia. It's a valley nestled in the Dinaric Alps, and it's renowned for its cultural and religious diversity. earning the nickname the Jerusalem of Europe. So during the Yugoslav conflict in the period 92-94, the Serb army, a unit of the Serb army known as the Sarajevo Romania Corps, commanded by Major General Stanislav Galic, the accused in my case, directed a deliberate strategy of unlawful mortar attacks and sniper fire aimed at the Muslim civilian population in Sarajevo. We prosecuted the case, and after prosecution we secured a conviction against the general for the breach of the laws of war, and the International Tribunal sentenced him to 20 years, and then in appeal, the appeals chamber enhanced that 20 years to life imprisonment. He's still in prison. In that case, the defense raised the issue that the accused was not attacking civilians per se, but that they were targeting only military targets of the enemy forces, which were mingling with civilian settlements. And therefore, the civilians and civilian settlements were mere collateral damage. So their position is, we only targeted the military targets, but they were mingling with civilians, and that's why the civilians were collateral damage. We didn't target civilians. I should note here that this is in fact an assertion that has also been made in respect of the last phase of the war here in Sri Lanka, in respect of the shelling of the no-fire zones in the theatre of war in the north, where it has been said that the LTT combatants were present in the no-fire zones, and that's why the Sri Lanka army fired the no-fire zones. Now, in the Galic case, the Hague Tribunal determined that attacks are prohibited if they are expected to cause incidental loss of civilian life or damage, that is to say collateral damage, which should be excessive in relation to the concrete and direct military advantage anticipated from the attack. Bear in mind, anticipated. Before the information to a military unit before attacking. In other words, if the anticipated collateral damage, i.e., the harm to the civilians and destruction to civilian objects, if it's disproportionately excessive in comparison to the military advantage anticipated from the attack, then you cannot proceed with the attack. And the court said that if, notwithstanding that knowledge, if you proceed with the attack, and then due to your attack, disproportionate collateral damage is caused to civilians and civilian settlement, then that would be a war crime. I know it's a lot of words and a mouthful. It's not easy to go through it, but I'm trying my best to confine a 4-year course into 1 hour here. Now, in the Galic case, court also determined that indiscriminate attacks, meaning you don't care of the proximity of the civilians to the military targets, you just happily fire and bomb away without taking any precautions to minimize civilian casualties, that too then constitutes war crimes. Therefore, the rule is care must be taken to spare civilians and civilian objects, including verifying targets and choosing methods that minimize civilian harm. Let me elaborate this with a hypothetical illustration. Say an attacking army unit is confronted with a refugee shelter, which contains over 1,000 civilians, including women, elderly, children, and disabled. The unit gets reliable intelligence reports that there are 30 armed enemy soldiers also hiding in the shelter. Now, the military commander of the attacking forces knows that the shelter also contains over 1,000 civilians. But regardless, because he wants to neutralize the 30 armed enemy soldiers, he attacks, he bombs the shelter and ends up killing 800 civilians and injuring, causing severe injuries to 200. Plus, of course, he manages to kill the 30 armed enemy soldiers. Now, an international court, going by the Galich jurisprudence, might determine that the collateral damage, i.e. the 1,000 civilians, is disproportionately excessive compared to the military advantage anticipated, i.e. neutralizing 30 armed enemy soldiers, and determine that the attack was a war crime. I hope with that illustration that theory of liability is clear to you. That's about the 4 Geneva Conventions. In addition to the 4 Geneva Conventions, in 1977, 2 protocols were adopted which basically reinforce the law of war, particularly in its application to international armed conflicts, which is Protocol 1, and non-international armed conflicts, which is Protocol 2. Then we have, I will quickly finish this, the Hague Conventions. In addition to the Geneva Conventions, which actually, I'm referring to primarily the Hague Conventions of 1899 and 1907, which are international treaties that establish the rules of engagement and define legitimate military targets. The foundational basis of the Hague Convention is that weapons and the methods of warfare that cause superfluous injury or unnecessary suffering are strictly forbidden. They forbid the targeting of undefended areas and reinforce the principle of distinction between civilians and combatants. So the Hague Convention sets specific parameters regarding the means of warfare. That is, it limits the choice of weapons available to warring factions. They specifically ban the use of poison and what is known as expanding bullets, projectiles. There are what you call dum-dum bullets that actually expands once it enters the body, causing unnecessary suffering to the victims. The Hague Conventions also paved the way for restrictions on chemical and biological agents in the use of warfare. The conventions regulate tactical operations, meaning it explicitly prohibits the bombardment or pillaging of undefended towns, villages, and private property. And it provides protection to historical monuments, places of worship, hospitals, and educational institutions. And it lays down the rules of occupation regarding the rights and duties of an occupying power over enemy territory, forbidding collective punishment and forced military conscription of local inhabitants. So this is in essence the laws of war in a, if it can be called a bird's eye view. Now, if you consider, for instance, Israel, it has been held, has been guilty of the breach of all these laws that I described here. You know, for instance, they have attacked civilians and civilian settlements in the Gaza. You know, UN investigations have reported that Israel has failed to take constant care to spare civilians alongside indiscriminate bombings of civilian infrastructure, including hospitals, schools, and clearly marked press vehicles. So clear, blatant breach of the laws of war. Then Israel's deliberate obstruction of humanitarian aid and essential supplies to the Gaza population constitutes collective punishment. This systematic deprivation has led to widespread famine, severely violating the provisions of the 4th Geneva Conventions, which strictly prohibits starving civilians as a method of warfare. In fact, in an advisory opinion, the International Court of Justice has, in The Hague, found that Israel's restrictions on humanitarian aid to Gaza and its attempts to shut down the UN Relief and Works Agency breached its international obligations. So I hope this gives you some idea about what laws of war are about. But if you viewed the legal provisions that I just discussed through the prism of Buddhism, you will no doubt recognize that the fundamental rules of international humanitarian law are designed to limit the suffering caused by war, which fully resonates with the Buddhist core principle of avihimsa, cause no suffering. So both IHL and Buddhism, international humanitarian law and Buddhism, share the foundational aim of preventing unnecessary suffering. And what's more interesting is the cardinal IHL principle of proportionality that I just discussed mirrors the Buddhist middle path by balancing military necessity with humanitarian restraints. So it is truly remarkable that 2,500 years before ICRC sat down in Geneva to deliberate and negotiate the laws of war, Gautama Buddha taught the world the moral framework upon which today's laws of war is built. Exceptional. Now, if you scrutinize the ground norms based on which the rules of war are built upon, you would agree with me that the laws of war actually codifies the Buddhist virtues. Ergo, a breach of the laws of war would also constitute a violation of the Buddhist moral framework that the majority of this country claim to follow. Then it begs a question as to why there isn't a loud call for accountability for the violation of the laws of war in this country, whether it relates to atrocities committed by the LTT or the alleged conflict-related crimes committed by members of the security forces, similar to the demand for accountability for corruption and other peacetime crimes. Because every time there is an attempt to investigate and prosecute conflict-related crimes, there's this false rhetoric that flies around that it is pursuant to an international conspiracy, when in fact the state's duty to investigate and prosecute serious crimes is entrenched in our own constitution. Now, we have some erudite senior counsel in the house, and they will agree with me here that Article 12(1) of the Constitution guarantees that all persons are equal before the law and are entitled to the equal protection of the law. This constitutional protection guaranteed to all persons, not only citizens, even foreigners present in the country, at the very minimum means that any person who suffers any grievance in the eyes of the law, in particular victim of a crime, as recognized under our law of the land, must be afforded legal protection to redress the grievance or harm. So at the most basic level, and Chaya will agree with me on this, this means that the state is constitutionally bound to investigate alleged crimes, and in the event prima facie evidence supporting the allegation is found, to prosecute the perpetrators. Now, our constitution calls upon the state to execute this duty equally and indiscriminately, regardless of who the victim is or regardless of who the perpetrator is. This is the cornerstone of any civilized society that upholds the rule of law. There's nothing foreign about it. But have we, as a nation, upheld the rule of law indiscriminately? That's the question I wish to leave you with. But for my part, I'd say, taking a leaf from the Buddhist philosophy, the middle path, Madhyama Pratipadava, the solution for Sri Lanka is between, it lies between vengeance and amnesia. Vengeance perpetuates hatred, amnesia perpetuates impunity and recurrence. Now, the Dhamma, I believe, would call us to a third path. Investigate credibly, prosecute fairly, remember truthfully, and heal collectively. Forgiveness is the right of the victim. Accountability is the state's responsibility, state's duty, constitutional duty. Remember Prashanthi Kumaraswamy, cycling home from school, was stopped at a checkpoint, gang raped, and murdered by those who were supposed to provide us security. So, when we uphold the rule of law for all indiscriminately, we uphold the Dhamma for all indiscriminately, and for every child still cycling home past the checkpoint. Thank you for your attention.
So today it is my pleasure and privilege to thank everyone who made this memorial oration a resounding success, and I'm sure you'll agree. It is with great pleasure that I take this opportunity to thank our esteemed orator, for a moment I couldn't see you there, Ms. Prashanthi Mahindaratne, for finally accepting our numerous invitations extended over many years to come and deliver the memorial oration. And it was indeed a very unique oration, giving us an insight into the principles of war, linking it with Buddhism and the Musaeus legacy, and something I have never actually thought of. So you have given us a lot of food for thought. You have also given us, as Musaites, a moment to bask in the glory of your success and the heights that you have reached, and a chance to relish in the association of a Musaeus College trailblazer. So you have also placed a lot of responsibility on my shoulders, I think perhaps being the only member of the official bar in this gathering. So I assure you that I will do my best to see that justice is done. And as always, we wish to extend our heartfelt thanks to our chairman and the board of trustees, including Mrs. Indrani Veerathunga, who never fails to be here, both as a trustee and a proud alumni. And we thank them for their hard work and commitment to make Musaeus College the leading girls' school in the country, and for their support of all MCPP activities. I wish to place on record our immense debt and gratitude to our president and principal, Mrs. Sajivani Bandara. Thank you, madam, for your extensive support in looking into all the finer details and last-minute requests to make this event elegant and flawless as much as possible. To our past principals and past presidents, Mrs. Nelum Senadira, Mrs. Shobha Sumanasekara, you have always been here with us, and you never fail to support us in all our events, and we are grateful, deeply grateful for your presence here today amidst your busy schedules. Thank you for being here. We thank the heads of faculty, the office bearers and the teachers of the Teachers Guild for being here on our invitation amidst your busy schedules. We also wish to make a special mention of our past teachers who continue to be in our hearts and our lives, leaving an indelible mark. And thank you for most graciously accepting our invitation and being here today. A special thanks goes out to Ms. Kanti Fernando, whom we fondly refer to as KF, who is endeared to many generations of Musaites, for being here amidst many difficulties today and to be here with us. We are indeed very proud to look at this august audience and see luminaries in their respective fields gracing this occasion as our honored guests. And we are humbly proud to say that some of these stars have had their foundations within these walls, imbibing the spirit of our founders and carrying out their vision with exemplary finesse. We thank you all for being here with us as we pay homage to those who have given us our roots. An immense debt of gratitude is owed to the non-academic staff, including Mahesh and the auditorium staff for all the tech support, Nishani and the Musaeus kitchen for their scrumptious food, the head of, Mr. Herat, the head of housekeeping, and his staff for their unreserved support in all of today's arrangements, and security for their constant assistance in making today a success, and the hashtag team for their photography and videography. This event would not have been possible at all if not for all the hands that pitched in to do all the big and small tasks that we have allocated to them with excellence, care, and diligence. I'm speaking of my EXCO. And that includes my partner in crime, my Joint Secretary Dinali, who is worrying about all the details at home while recuperating after surgery when she's supposed to be resting and taking things easy. The MCPPA EXCO always rises to any occasion, and we all stand together as one to handle each and every event. And I thank each and every one of my EXCO for the numerous things they have done, often with, as I said, very, very little notice, to make this day a success and a reality. And I must also take this opportunity to extend the thanks to two non-EXCO members, Maheli and Dilushi, who have helped us immensely with the graphics, which demonstrates their love for the school and the sisterhood. Last but not least, I would like to thank you all, our sisters, our new and old friends, for being here today to honor those who created this legacy, for making sure that we unite as one sisterhood, as one Musaeus, and hand over this legacy, this Musaeusness, in the words of our esteemed orator, to the generations to come, enabling them to build on it and hone it to suit the future. On behalf of the EXCO, I urge you to participate in more of our events. Reach out to us, even if there is no event, because we are here to hear your voices. And together, we can make this sisterhood, this community, the Musaeus legacy, better and brighter. We are always stronger together. Thank you, and have a good evening.